Shay, if you could turn on your mic and your camera, we'll be able to see you. Everybody, welcome Shay Williamson. She is General Counsel at the TIREX Group. She's going to be talking to us again about 3D printing and legal liability, keeping up with this theme. Thank you so much for joining us.
Hi, thank you so much for having me. I'm in Austin, Texas, and I'm a native Texan, so this global initiative is very exciting for me, and I am limiting my talk about the American law and what you can expect in America. So if you're in other jurisdictions, in a lot of ways, other countries are much more advanced than us in civil law. Kate is a patent lawyer. I don't do patents. I do trials. I've been practicing law for about 34 years. Most of that has been all in trial litigation on the civil side. And when I came to this company called TIREX that I'm at now, that has 10 tech companies underneath it as an umbrella, I wasn't familiar with 3D printing until about 7 months ago. And I said, well, why would you want me? And why would I want you? And he said, my boss said, well, we're very, very scrutinous about a liability. And if anybody can keep us out of court, you can, because I have done both plaintiffs and defendants work. So let me share my screen. I have a few slides for you. Okay, so this talk is kind of imperfect because there is such a gap between the law as it exists and 3D print. There's so many applications of 3D printing now, and the law has not kept up with the technology going forward. Sorry. So you've heard a little bit about me, that I'm a native Texan. To the right are the companies that I represent, TIREX being the main innovator, and we are technology innovators. TIREX does a multitude of technical things, and all of them touch or have a component of 3D printing, very much in the additive manufacturing game. So what is funny about 100 lawyers in a room? Nothing. There's nothing funny about that at all. So you have to be a sophisticated consumer when you are looking at litigation, you're looking at patent issues. You are the client. Never forget that. You are the client. We work for our clients, not for ourselves. So navigating law and 3D printing, I have some tips and tricks to keep you out of court. The highest billing average right now is $362 an hour for bankruptcy and IP attorneys, intellectual property attorneys. And that is just a median kind of number. So if you're doing the math, you can understand why Kate says, yes, it takes this range, this much. We don't know how much it will be. It could be a lot more than you ever anticipated on being. In 2005, the first record was set by a lawyer in New York for charging $1,000 an hour. Now I hear that number has increased to $1,500 an hour. So you can see how lawyers were kind of pricing ourselves out of the market. So from PERSA, from my view, we do everything from mini PERSAs up to carbon printers, up to larger printers, just a whole array of anything 3D printed. We have some nano printers that we also use, and we're getting into biomedical printing as well. So it's a really big intersection of things, including food. We have a bunch of food printers. And I was telling one of my colleagues, one of the neat things about working here is my boss insists that everybody learn how to 3D print. So that was my first first task was to learn how to 3D print on a person to give everybody a bigger understanding of what our mission is. So from that to 3D printed houses up in Georgetown, which is just about 30 minutes north of me, they're printing houses now at the rate of a house in 30 days finished out. And that is with Icon and Lanier. Icon is also an Austin-based company that won a contract with NASA to do space houses for Mars project. Oops. So space and beyond, we don't know where this technology is going to lead us. In the meantime, we have a whole host of maybe possible lawsuits, litigation, judges who don't understand what's going on. Juries for sure don't understand what's going on. And the uncertainties of litigation are astronomical. So I know everybody here knows what 3D printing is, but we need to start with the definition that a court can look at, a jury can understand. It is the action or process of making a physical object from a three-dimensional digital model, typically by laying down many thin layers of a material in succession. That's very, very basic, very descriptive. And I can tell you, when you can have all the complex litigation you want in the world, but when we go to court, that's probably the definition that they're going to use to define 3D printing. Here we go. Sorry about that. I'm having some trouble with my slide. I apologize for that. Okay, I'm going to continue on. Tell you that a lawyer talking about 3D printing can't get her slides to go. Anyway, the next thing I want to turn to is to kind of explain what the American system is of civil litigation when a plaintiff is suing a defendant for money. And all we have in Texas, in the United States, is money for a compensation. So we're always talking about a dollar amount. Litigation is very expensive. It's expensive for the plaintiff side. It's expensive for the defense side. I've been on both sides, and it costs are driving up every single day from what we see. So looking at our negligence part, well, I don't know why my screen stopped. There we go. There we go. Fixed it. That's Texas style, just kind of messing around with it till it just fixes itself. So we have too much technology too soon. The law has lagged behind our technology. And the problem is there's little, if no, regulations or standards for 3D printing. So we have to work with what we have. We can't make it fit, or we can't, the law is very slow to evolve. So I can tell you the basics of what we have now and how we have to make 3D printing fit into this civil law system. First of all, in a civil case, it is the burden on the plaintiff, the person bringing the lawsuit, but only by more than 50% of the evidence. So all they have to do is tip the scales just a little bit, not even the full 51%, and the plaintiff wins. And we've had some astronomical verdicts in the United States, especially involving pharmaceuticals, big companies. We had a $2.5 billion verdict that was set by a jury for one case. That was one case. The judge remanded the damages back to like 85 million, but still, we were talking a high risky concept of going to court. this burden of proof, this tipping the just tipping the iceberg, if you want to say, or tipping the scales, is different than our criminal cases where we have to show beyond a reasonable doubt that the defendant is guilty and should go to jail. So all the defense has to do is raise a reasonable doubt. Negligence is the basis of our tort law. Negligence is what a reasonable and prudent company or a person would do in a certain situation. And whatever that is, that's what the jury has to figure out. They're going to be given that instruction in every case, in personal injury, property damage, intellectual property infringement. They're going to be giving a negligence instruction that they should just figure out what a reasonable company would do. The problem is we don't have a lot of case law about what reasonable is when it comes to 3D printing. And then what damages there are. In patent infringement cases, you can get into astronomical damages on loss of products, investors, injury to business, etc. So plaintiffs are those who are suing for damages. Defendants are those who are defending the lawsuit. We've got these juries, and these juries aren't sophisticated people. They're people that have a driver's license in the jurisdiction that they live in. And so that's how they pick the jurors. They don't have any concept of 3D printing or that kind of thing. And it takes a really good trial lawyer to figure out how to get a pool of those jurors down to a panel that will be favorable to them. And then we have the judge. The judge is either elected or appointed. If it's a federal case, the judge is appointed for life. It means usually they run their courtroom any way that they want to. And we all dot our I's and cross our T's, especially in federal court. In state court in Texas, our judges are elected every 4 years. So who are the possible parties of these lawsuits? You have producers of the parts themselves, additive manufacturers, the holders of intellectual property. They're saying you're infringing on us by making this certain product. It's not different enough. It's infringing on our patent. You have the end users of your product. You have your own contractors and employees that you have to worry about for on-the-job injuries, if they've been discriminated or have a federal lawsuit under the Civil Rights Bill. You have your contractors that you contract with. If your contractor's employee is hurt on the job, who's going to take assumption for that type of risk? You have your investors that have come to you with their money, want to innovate, put money into an entrepreneurship type company and really are seeking a big return. They might sue you. And your end customers are also a source of parties. So theories of litigation for 3D printing. We've talked about negligence, failure to do what a reasonable person would. Whatever that is, I don't know what it is. I would have to find an expert in 3D printing that I could prove in court was an expert in order to explain to the jury what a reasonable 3D print company would do or not do in a certain situation. Under the Products Liability Code, we have something in America called strict liability under the Uniform Torts Code 402A. It's one who sells an unreasonably dangerous product if it reaches the seller in the substantial form that it was manufactured in and it causes damage to a user or consumer. You don't have to prove negligence. You don't have to prove a mindset. You don't have to prove that the seller intended to produce a damaged good. You don't have to prove any of that. So products liability, strict liability is very important in American law. And then you have your contract theories of argument. It's an agreement, of course, but what does that mean? It means that there's a promise to do something and there's a consideration paid. Now, the consideration it doesn't have to be money. It can be a variety of things. It's a quid pro quo kind of relationship. there's a material breach to the contract. So it has to be material. It can't be, a mistype, it's a T or something. That it has to be a material breach to the contract. And there can also be an anticipatory breach of your contract. In other words, if you're acting like you're not going to comply with your contract, for example, you have a lease on a building and all of a sudden you're moving out, 3 days before the lease takes effect and you're supposed to pay, then the leaseholder could go ahead and sue you for anticipatory breach. Patent right infringement. Kate did a great job doing that. That is a very specialized part of the law. And I have a patent lawyer. We have a patent lawyer, and her advice is right. You need to seek a patent lawyer. And I know that some patent attorneys do things on a fixed price based on the complexity. So at least you have, some idea of how much it's going to cost. But how much it's going to cost, we don't know. Trademark infringement. If you have a unique name or a logo, then you should be registering that for a trademark. You can sue if somebody uses your trademark without your permission. And then what we call in Texas the Deceptive Trade Practices Act. This is a theory that is enacted in some way in every major state. And basically what it says is for deceptive practices, if a consumer, and it has to be, it's not a business, but if a consumer is deceptively treated in the way that they buy something, or they buy something, it's not the quality they thought, it breaks, it hurts them, it injures them, whatever, they can bring a lawsuit and claim treble the damages. In other words, whatever their damages were, plus attorney's fees, plus interest, plus the original damages. So that is okay. E-discovery. I wanted to point this out really quickly, I know that a lot of you out there, you have in-house counsel, you may be a victim of a lawsuit that's going on, not real happy about it. I wanted to touch on e-discovery because something my clients don't understand is e-discovery after they've already been sued, when you really need to be proactive when it comes to litigation. E-discovery is electronic discovery, and discovery is known as a process in the United States where the judges make you exchange information about the lawsuit. It can be papers, it can be email, it can be whatever. And if it's electronically stored, it has to be produced in the way that it was stored at the time that it was made. In other words, all the metadata attaches to the e-discovery. Any properties around that document attaches to the e-discovery. And I've been in lawsuits where we're talking like really literally talking millions of pieces of paper that are electronically imaged and produced in a lawsuit. So one thing I like to tell my clients is that ask yourself before you send that email if you would like that email to be read on a big whiteboard and in front of a jury, because maybe you don't, or maybe you'd like to have a private conversation with somebody before you document something like that that is going to be going to the other side, or you're going to be involved in a lawsuit over it later on. There are some privileges against disclosure. In other words, some documents that are considered privileged in a lawsuit that can't be produced to the other side. And these, of course, are your attorney-client. And you have to be sure, even with in-house counsel, that they are attorney-client designated documents. This information is privileged, judge. And, you can look at the face of it. I usually put attorney-client privilege on everything I do or send to a client so that I don't waive that privilege. your attorney work product. So whatever your attorney does for you, investigates, takes deposition, all that internal work, all of that is privileged from going to the other side. Consulting experts, which in 3D printing and additive manufacturing, these lawsuits that I expect will come, they will come. They're going to be very complex, lots of documents, lots of technical information. So in that event, I would probably pick up the phone and call what I call a consulting expert, somebody that I may not want to testify to the jury, but someone who can review all the documents and give me an opinion on whether there's been a patent infringement or trademark infringement or whatever the issue is, a commercial breach of a contract. And whatever that consulting expert tells me, that I don't have to share with the other side. I don't have to share with them until I make them a testifying expert. Trade secrets and proprietary information. This is so important for y'all. You want to really guard your trade secrets and proprietary information very carefully. If the other side can show that that information was given to a public party or there was intent to disclose it to the public, it's not privileged anymore and you have to produce it. So you want to make sure that you guard and protect your trade secrets and proprietary information. And then investigation done in anticipation of a lawsuit. Like, you're getting a lawsuit. You've got a letter, so you've got a date. Everything that you do after that, in anticipation of that litigation, is protected from disclosure. Safety. Make sure you have a safety procedures in place for your workers. Make sure you have the proper workers' compensation plan or an ERISA plan that substitutes that. And make sure you have the right kind of insurance, not before the lawsuit, not after the lawsuit, but way before the lawsuit. Think of the risk that your company is exposed to and get that applicable insurance. Treat litigation proactively. Have non-disclosures with everybody you do business with, even your own contractors, and be sure in your contract you have a good contracts lawyer. It's going to have an arbitration or ADR provision in it where you can't file a lawsuit. You have to go through arbitration or mediation if you have a problem with the company. So it keeps you out of litigation, and also you can specify where that arbitration, that litigation is going to preside and what law is going to apply. We do a lot of business and they like to have their, either in California or New York, whatever state they're in, they usually insist on having that arbitration agreement in there with their own jurisdiction. So they can't be sued in Texas. If you do get any inclination of a claim at all, verbal, written, whatever, please put your insurer on notice immediately. I know claims, we don't want our premiums to go up. I know all that, but in these complex cases, you cannot jeopardize your insurance coverage. So at the risk of the company. So please do that. With that, I'll take any questions. This is just a very exciting experience for me. I'm pretty animated, so I'll be glad to answer any questions you have.
Shay, that was so interesting. A lot of critical information that you covered, really helpful. I'm a business owner myself, and I think you touched on a lot of important aspects of the legal process and litigation. We do have questions from the audience. Have you seen product liability cases involving 3D printed parts yet? If you have, could you give us an example?
I have not, and I am looking. That is an active research of mine that I'm doing at Baylor University, and I have not found that yet.
How is 3D printing different from desktop printing? Is it the file and or the design? Is that it? What is the question in that type of litigation?
I think that I think that that's the problem, is that the print definition that we have, and I know there's been some litigation with the patent office on whether you can 3D print and have a patent on that particular product. But I think that the print the old idea of printing is not kept up with what we have today. I don't know if that answers the question, but we don't have a really good definition, I think, of 3D printing.
Mm. What are some of the common mistakes you see that result in litigation? I think you touched on this on one of your slides, but
Um,
if you have anything to add.
Yeah, for example, a lot of contract breaches. I would say a whole lot of people that don't live up to their contract, breach their contract. A lot of I didn't pay what I was
Yeah,
supposed to pay
I was
under the
gonna say.
contract. That's
Mhm.
one of the most important ones. And those cases, you usually, if you're suing under contract, you can usually get your attorney's fees as well.
Yeah. Are there any recommended best practices in finding a patent attorney to work with?
Oh, another one. That's very good. I would just, first of all, look at your jurisdiction where you're at, and find out where that lawsuit would be filed. In other words, you wouldn't believe it, but 70% of patent litigation is filed in Marshall, Texas, in the Eastern District, because there were so many good verdicts coming from patent infringements. They all started suing there. So I would kind of look in your local area first, go to your state bar web, and look for, they have everybody there. You can start there and then check them out through Avo and other legal platforms that will give you ratings on those lawyers.
This is a good one. What cases do you predict are on the near horizon in the 3D printing environment?
I have some interesting, part of my research is focused on forensic evidence. So there's been some cases from the UK where they actually were able to admit parts of 3D printed bone in order to get a murder conviction. And that's kind of one of my interests, is actually proving up this type of evidence for the jury to consider. So I think that's going to be a very interesting issue.
Wow. Have you seen any legal activity surrounding export control for additive manufacturing?
I personally have not. I have not.
Okay. You touched on a lot of very interesting and critical topics, answered a lot of questions for me personally or professionally. So thank you so much for joining us. And will you be around in the networking sessions after this block?
Yes, I will. I certainly
Okay,
will.
great.
Thank you
So
so much.
thank you so much for joining us. Catch Shay in the networking for more questions and to talk about legalities of 3D printing in more detail. Thanks so much, Shay.
Thank you.